5, 4, 3, 2, 1. We are told that in some cases suits are pending in various courts and where decrees have been passed, appeals are pending in appellate courts. Such suits and appeals will now be disposed of in accordance with the declaration granted by us. We are told that there are few cases where suits have been decreed and the decrees have become final, no appeals having been filed against those decrees. The decrees will be binding inter partes and the declaration granted by us will be of no avail to the parties thereto. Emphasis supplied, it is therefore apparent that where the suits have been decreed and such decrees have become final, since no appeals have been filed against the same, the said decrees are binding inter partes and the declaration made by the Supreme Court is of no avail to the parties thereto. In the present case, as mentioned above, the suit for preemption was decreed on 27/8/1983. That decree was affirmed by the Court of Appeal on 30/11/1983. The second appeal filed before the High Court against the judgment and decree of the trial court and the Court of Appeal was dismissed on 5/4/1984. It is the admitted position that at no stage the appellants questioned the validity of the decree question before this court. We are informed that after 12 years, in the year 1986, a special leave petition has been filed against order dated 5/4/1984 passed in the second appeal by the High Court. However, the fact remains that when the High Court allowed the civil revision filed on behalf of the respondent on 23/1990, the decrees of the trial court, the Court of Appeal, and the High Court in second appeal had become final. As such, the direction of this court in Atam Prakash's case supra that such decrees shall be binding inter partes, notwithstanding the declaration of this court in the aforesaid judgment, was fully applicable in the present case. The High Court has rightly come to the conclusion that notwithstanding the judgment of the Constitution Bench in the case of A. Prakash supra, the decree in the suit for preemption filed on behalf of the respondent was binding between the parties. On behalf of the appellants, our attention was drawn to the substituted section 15 in the Punjab Preemption Act 1913, which has been notified on 7th May 1995, and it was urged that after the said amendment, no right of preemption can be enforced. Section 15, which has been substituted, is as follows. Right of preemption to vest in tenant the right of preemption in respect of sale of agricultural land and village immovable property shall vest in the tenant who holds under tenancy of the vendors the land or property sold or a part thereof. On a plain reading, the aforesaid section has been introduced prospectively, and there is no question of the said section affecting in any manner the judgment and decree passed in the suit for preemption as early as in the year 1983, affirmed by the High Court in the second appeal in the year 1984. According to us, the impugned order passed by the High Court is in terms of the direction given by this court in the judgment of the Constitution bench in A. Prakash case supra, and we find no reason to take a contrary view. These appeals are accordingly dismissed. No cause. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.